Welcome to trusts. We are mostly going to be dealing with a private express trust, meaning that it's a private individual beneficiary. We do touch on charitable trusts, which is a unique beneficiary with some unique rules. Just as part of a review for testate succession wills, take a look at this word scramble and try to make sure you understand basically all of the terms and concepts. First, we're going to look at the parties to a trust. A settlor or grantor is the one that has both legal and equitable title, and part of what that settlor is going to do is sever that. The legal title goes in the hands of the trustee, which could also be the settlor, and some portion of equitable title goes to the beneficiary. A beneficiary reaps the benefit. Can be a current beneficiary holding a present possessory interest, or their beneficial interest could be postponed. We will also be examining the trust terms that establish the relationship between the trustee and the beneficiary. Those terms are created by the settlor in the document. One thing to think about is that if we ever have a merger in one person of the sole legal and equitable title, there is no trust, because the some separation of legal and equitable title is the unique aspect of a trust. Why do people create trusts? Mostly for flexibility and control. They want to manage their transferring of wealth from one generation to the other, as opposed to outright ownership. Looking at the trust requirements and comparing them in a lineup against wills, the number one thing that should jump out at you is the fact that a trust need not be in writing. A term that the settlor might use is called a declaration of trust. And the settlor can declare a trust by remaining in the role as legal owner and holding that property for the benefit of others, or even for the benefit of the settlor for life, then to others. That is a sufficient declaration of trust. As long as there's some severance of legal and equitable title, that will be enough to create a trust. Take a look at the problem and how the doctrine of merger would say that you have legal and equitable title in one person, and thus the trust fails. Why is that problematic? Why do we care if the trust fails? Beneficiaries, they reap the interest. If you get to pick which party you want to be the beneficiary, okay? They get to use it. This is where we will eventually talk about present and future interests. You can name beneficiaries by a group known as a class. We have to apply the class closing rule. When does the class close? Take a look at the problem and determine when that class closes, whether or not you think that might be consistent with what most settlers would want, and how might you draft it differently. And in drafting it differently, does that create a rule against perpetuities problem? All right, the trustee, they're the manager. They are a fiduciary. As a fiduciary, they owe the duties of loyalty and care, and therefore can be sued for a breach. They hold legal title. When you go to the bank, you see the title is in the name of the trustee. They get to earn a commission based on the value of property. As a preview for the next class, we need to think about the two types of trusts. A trust can be either created as part of the will, known as a testamentary trust. You've got to satisfy both the will and the trust requirements, or it can be created as a separate document, inter vivos, meaning during lifetime, in which case it could be either revocable or irrevocable. And in both cases, an inter vivos trust is non-probate as long as it has provisions and doesn't fail, and will pass outside the probate administration process, and will not be controlled by the will or intestate succession. We need to understand that there are revocable and irrevocable trusts. All right, let's again look at the relationship between the parties, the settlor, the trustee, and the beneficiary, keeping in mind that the trustee is the manager. And once the settlor creates the trust, the question as to whether or not a trust has been created oftentimes depends on whether or not the settlor has imposed any type of legal obligation on the trustee to do something, as opposed to wishy-washy or precatory language, wishful thinking. Okay? Now we're going to look at the codification. Maryland adopted the Maryland Trust Act, which was based on the Uniform Trust Code. There is a laundry list of the factors that we need to examine. Capacity can be presumed unless otherwise indicated. Intent. Did we impose a legal obligation on the trustee to do something? Looking at the settlor's words. Do we have an ascertainable beneficiary? This is where it will deviate from the charitable trust. We need ascertainable, definite beneficiaries. We need trust property, something for the trustee to manage, and of course, it must be established for a lawful purpose. So as we look at the two cases that we have on trust intent, the question we ask, did the settlor impose a legal obligation on the trustee to do something? Shall, manage, distribute. Taking a look at the problem, which is nothing more than precatory language. I hope my brother will provide for my children. That is not enough to impose a legal obligation on the trustee. Ideally, what we want is mandatory language. Trustee shall, brother shall pay for something, shall make certain distributions. Again, we're looking at that the settlor's words, the trust terms, to determine if the settlor imposed a legal obligation on the trustee that the beneficiary can enforce. Taking a look at Spicer. I've done my 5-point case brief here to understand the facts and whether or not a trust was intended. The decedent died with a will naming sister as executor. That relationship is important. And give my sister a residual bequest and to be disposed of as we agreed. Potential trust. Is that enough to impose any type of legal obligation on the sister? Well, not really. And some of the arguments that are used are things that we will cover later in trust called a resulting trust. Not really a trust at all.